Well, perfect. I know we've got some additional people who are going to join us, and we will let them continue to come in as they're able to log in. But we are going to go ahead and kick things off. First, let me say welcome to everyone for joining us today. It's Gulfstream Legal's January Poolside Chat, our first one of the year. We love doing these and meeting everybody as much as we can. Today's conversation is sink or swim in the privacy pool. I am joined today by my good friend and my honored guest, Tom Matson. Tom, say hello to everybody.
Hello.
Well, perfect. Well, Tom, I'm going to let you introduce yourself a little bit to everybody, and for those who don't know you or what you do.
Thanks, Ari, and thanks to Gulfstream for inviting me to speak today. My name is Tom Matson. I'm the president of Matson Consulting Group. I'm based here in Austin, Texas, where it is 78 degrees outside, but they are cutting trees, so I will not be at my pool today. So so what do? Started doing international eDiscovery about 22 years ago. That led into privacy about 15 years ago, and I pretty much strictly do privacy for various clients. I'm a DPO under the GDPR for a couple of companies as a contractor. I also do CCPA, CPRA, Canada, most international privacy laws. Somebody will call on me to help organize. If they can or can't comply, that's one thing. But I've traveled to about 36 countries to get data out of, in my experience, and learned a bunch of laws, rules, regulations, things to do, things not to do along the way. And I also do some OSINT investigations in social media, so open source information stuff, which kind of crosses between discovery and privacy and social media and this dark pool of how humans interact and how we get data out. So I kind of do all of that. Today we're going to focus on a couple topics where I think the ground rules are people can ask questions in the comments. We're going to, we have 30 minutes. I speak regularly. I could probably speak 10 hours on each of these, but we're going to try to relay as much information and take questions regarding the CCPA and the CPRA out of California, regarding whether or not the U.S. is heading towards a national privacy law, because I get that question a lot. Why do I want to spend a lot of money complying with these individual states' laws when we can just count on our trusty federal government up there in D.C. to do the right thing? So we're going to hit on that and talk about where I think that's going. Tend to be rather opinionated as my speaking engagements go. I've been accused of that, but I work for myself, so I don't need to give a disclosure. What I say may not be what Gulfstream thinks, but I can't really fire myself, so I tend to have opinions. So I think we're going to start kind of going over, and then we have a poll question. Ari, when do you want to frame that?
Yeah. So what we'll do is let's dive right into our first topic, and then we'll post the poll so people can review that while we kind of dive into our second topic. So okay. Everyone, kind of as Tom mentioned, we're going to kick things off with a most popular topic that we've seen here recently, which is the CCPA, CPRA. What is being enforced in year one? What may change now that the CPRA is actually, it's not enforceable yet. I realize that's not coming till mid this year, but let's kind of kick off, to frame this conversation. What is the CCPA and what is the CPRA, and how is the CPRA, kind of tied in with the CCPA? So sure. Let me say, to kind of kick things off, for anybody who doesn't know, the CCPA is the California Consumer Privacy Act. It was signed into law in California back in June in 2018 and became effective January 1st, 2020. So this was one of the first data privacy regulation acts for a state in the United States that actually became enforceable, and was often compared to the GDPR, especially when it first came out. The CPRA, the California Privacy Right Act, however, took effect this January, so January 1st of this year. Is that correct, Tom?
That's correct.
And then enforcement is starting, if I've got my date correct, it should be July 1st of this year. Correct. And so the CPRA, kind of works hand in hand with the CCPA, but adds in a lot more details, including its own regulatory body that'll take over regulation and enforcement from the Attorney General, basically the State Attorney General of California. So there's quite a few more details that kind of get enacted in this. So let's kind of dig right into that. So Tom, with both of these things coming to fruition now in 2023, what are you seeing going on, and how do you see the CPRA really having a different impact, especially once enforcement happens later this year?
Yeah, sure. So the CPRA amends the CCPA. So I just want to, it's not for purposes of our discussion a new law. It amends, it fixes a lot of the quote problems. So it's also important to remember both of these are ballot initiatives passed by the residents of California, right? So this wasn't just strictly people in Sacramento. People in Sacramento now had, and the state legislature had to try to codify and write language around and that created some problems. If those of you familiar with it, we don't need to go into that. There was some, so it corrected some even typographical errors. But for the main part, the CPRA takes it a step further, and we're going to throw acronyms around. So it was starting as of January 1st this year. It is in play, and it will be enforced in 6 months. That's a lot of these privacy laws, even in different states. They kind of give you a period to ramp up if you're behind. What's different about the CPRA, I'm just going to jump to it in the interest, in my opinion, kind of what the big differences are. So the CPRA extends 2 more rights to California residents. So originally, similar to the GDPR, if you're familiar, your residents, your customers have the right to know, right to delete, right to opt out, right to opt in. That's California kind of puts 2 there. Non-discriminatory treatment and right to initiate a private cause of action in security breach cases. All right, not privacy cases. The CPRA gives them the right to correct data and the right to limit the use and disclosure of sensitive personal data, which sounds very legal, and that shouldn't mean much, right? All right, until you go to what is sensitive personal information, right? That's your social security number, driver's license number, login account to your banking account, your geolocation to within, I think, 8 feet of your house, right? You get into your race, your ethnic origin, philosophical beliefs. So it's pretty much everything. So it's the CCPA and the CPRA have always really itemized what personal information is, what sensitive personal information is, to almost a granular detail that's beyond needed. Unlike the GDPR, where they don't even mention personally identifiable information in the whole law, it's just implied. So there's one difference. But if you've prepared for GDPR and you've prepared for CCPA, the CPRA's biggest differences are, 2 big things. Prior to the CPRA coming into effect, there was an exception for your own employees to make these data subject to action requests. That is gone. That did not make it in. So a lot of people sat on this thinking, so if you're a law firm on this call and you're based in California or you have a California resident, they could, as of today, ask for every email you have about them, their employer, all right, their own, and that makes people go, huh, right? And there's exceptions, obviously, but what would you do? And you got, 30, 45 days to respond, right? So that employer-employee kind of carve out from the CCPA goes away. Similarly, there was a carve out in the CCPA for B2B kind of communication. If you're a business passing data to another business, would it really apply? Well, now this does apply. So now, similar to the GDPR, you as a data, they don't use controller processor, but you in charge of data in California are now responsible for your vendors' vendors, and your vendors' vendors, right? So that changes now your due diligence process. So getting rid of, the 2 new rights aren't, earth shattering. You do have to then, understand what that sensitive personal information is. But I think a lot of people have been caught off guard by the employer-employee carve-out being gone and the B2B kind of carve-out being gone, especially in the marketing and advertising sense, because that's where a lot of companies are sharing data, partnering with the bigger companies, the Marketos, the Google Analytics, saying, oh, they know what they're doing, so I'm safe. No, I would not. You're not. You have to understand what they're doing with your data. And we don't have to go into that. But the CCPA, CPRA enforcement So there's been some lot of articles at the end of last year, I think December. A lot of law firms, maybe some on the call, wrote their summaries about what was going on in California this year. Are they really enforcing it? What's good's a law if they're really not going to do anything about it? And the big case that caught the headlines was a case against Sephora, which happened in the latter part of last year, where the attorney general fined them, I think a nominal amount, I think it's a little over $1 million, for failure to implement global protection controls on the website use. So one thing that CCPA and CPR, I'm just going to call it CPRA instead of both because that's morphed into it. One thing you're going to have to add to your due diligence, whether you're a company or your clients, is you're going to have to add a website audit now to a thing you need to do every year, based on what it's my opinion. It should be part of every due diligence. Put it along with your SOC due diligence, all that. You're going to have to do a website analysis over. So, what are global protection controls, and how did they end up costing Sephora $1 million? So, different CPRA prevents you from selling. People can ask you to not sell their information, right? You have to put a button on there and saying, "Do not sell information." Sell doesn't mean it has to be for money. It can be disseminate, share, pass along. It's very broad. So a lot of nonprofits and some think tank folks are developing tools to plug into your browser where you click it once to say, do not share my information. And now you don't have to do it with every pop-up for every website you visit. So the GPCs, that's what the Sephora got in trouble for. So people were trying to implement those and they weren't being followed. So the website wasn't interacting and respecting those choices. All right. So that, amongst other things. So some people would argue Sephora would be happy with the $1 million fine. They made so much other money out of it. It was a slap on the wrist. But like everything with privacy, one side says that's too harsh and the other side says that's not harsh enough. Rarely do you ever find, different sides agreeing in the middle. So in the GPCs, you should probably look into it if you are operating a website. Because one of the key people that was responsible for developing that is now the person in charge in California under the AG, as Ari was saying, under their California Privacy Protection Agency. The gentleman that helped design the global protection controls is now in charge of the California Privacy Protection Agency under the Attorney General. So he's going to have a lot of knowledge and understanding. So that's one thing that was enforced last year. There was lots of other, that made the biggest headlines because that was kind of the first fine of size that went out. But in a lot of last year, there was a lot of letters, a lot of, hey, stop this. But as the Attorney General said last month, the gloves are coming off. I think that's his quote. They're going to start enforcing heavily on the CPRA. Up until this year, January 1st, you would get 30 days to cure. So if you were doing something wrong, if you didn't have that, please, don't sell my information. Or if you weren't responding to data subject action requests per a resident of California's right, you'd get a letter usually, hey, what's going on? What are you doing? And if you had this 30 days to figure it out, no problem. That 30-day cure also goes away now. So those would be the three takeaways. No more employer-employee carve-out, no more B2B carve-out, and that 30-day, we'll figure it out if they find us, is gone too. Now, you have 6 months because the CPR is not going to go into quote enforcement mode till midsummer this year, but I would expect a pretty big rollout of action by the California Attorney General's office Q3 of this year, Q4 of this year. And
so
I'm going to pause. Go ahead, Ari.
Yep. I was going to say, so let me ask you that, and before I ask you a question, so everybody who's attending, if you do have any questions for Tom or myself as you go, please feel free to enter them into the chat. We'll be glad to address any questions you have or anything along those lines. But Tom, let me ask you this. So, especially knowing that these enforcements and realities are coming, and they're coming soon, what strategies do you think people can start to discuss, enact, look for, enable in their own environment to be prepared prior to, and even a potential, enforcement request?
Yeah, and I'd say similarly what I was telling clients, a year or 2 years ago, you got to have kind of your plan, right? So this whole concept is data protection, not just data privacy. So it's also securing data. So make sure your organization has a response plan if there's a breach and know which of these laws would apply, because there are reporting requirements for every state. So that's just generally speaking. Specifically to the CPRA, you're most likely going to get in trouble with your website, with your sales or marketing team, or some combination there, or a data breach, right? In my opinion, those are the three riskiest areas where somebody might report you, right? So you do have independent nonprofits going around trying to find problems with big companies' websites. That does happen, and then they report it. But most likely, make sure you have timing restrictions similar to GDPR. How are you going to respond in a timely manner to what data? Say one of your customers says, "What data do you have about me?" Well, how are you going to go about that? You need a data map. You need to understand where the data lives. You need to understand your obligations to your vendors as well. So you have to check all your contracts to make sure the data sharing sections of those contracts are proper, and make sure your privacy notices on your website are indeed true on what you're doing with their data. So the standard checklist of things from the CPRA doesn't necessarily change that, but if you haven't started that because you've been like, oh, we only operate B2B, we don't have end users, we don't really market directly to California. Okay, now you got to do that risk analysis yourself, right? Because these rights vest with California residents as defined by the California tax law, which is a little more specific than GDPR, which is, are you an EU resident, which doesn't always mean citizen. So, if you're a Bank of California, or if you're a Bank of New York and you have a California resident, you have to do the analysis and the test. And there's a bunch of factors. Does the CPRA apply to you? You have to be of a certain size or have data of a certain number of people. So if you're a single operation dry cleaner, it's probably not going to be a problem to you. But, you should have all that homework done ahead of time to know, yep, this applies to us. There's even in how much data do we have? Can we identify California residents from other residents, because they might need to be treated differently? And check on your marketing pieces. Don't just chalk it up to, hey, we have, that's usually where I spend a lot of my time, is Marketo linked to Salesforce, linked to, you go to the IT guy, how many cookies do we have on our website? Because, you can't, there's a way you have to do that correctly. And they're like, we probably have 5 or 6, and they have 92, right? Or, why do you have those? What are they doing? Are you tracking, everything from keystrokes on down to geolocation? Because if you are, now you're in sensitive personal information mode, and you got to find out how to get rid of that if you want to stay, I would argue, in compliance. So I think you're on mute.
I do that on a regular basis. So that we have time to kind of chat about everything, because you and I both know how long we can go just about CPRA. So I'm going to real quickly launch our poll here, and everybody, please feel free whenever you want
I'll give a little background about it, Ari, or do you want to
answer?
tell me?
No, please. If you would, that'd be awesome.
So there's a lot of discussions about TikTok, ByteDance. Some federal government agencies are preventing it from being on government phones. Some University of Texas down here is preventing it from being accessed via the school's Wi-Fi. And I have some unique things. I was on an eDiscovery matter against ByteDance, in all honesty, so I have a pretty good understanding, more than I ever want to, about what TikTok does and actually what it does and doesn't do. So we're just curious, if you would support how did you word it? Like, your employer banning TikTok from phones?
Yeah, should employers ban social media platforms like TikTok from use on company issued devices and use on company Wi-Fi?
All right. So do you want to move on? We'll give them a few minutes to answer, then we'll come back to the results.
Yeah, exactly. So I see responses coming in, and we're shifting right now. So kind of we'll use this to kind of segue into our next topic, which is, is a national privacy law, which referred to the ADPPA, likely this year? Before we ask a couple of questions right there, why don't you give a quick overview, Tom, of what is the ADPPA? What's some history behind it? How are we looking at it? Why might it be necessary? And how is this going to make certain privacy laws like the CPRA evolve or impact it?
So I've spoken on this for like 10 years, and I'm always like, don't hold, because you can imagine there's lots of different state laws, and that's kind of the big thing with privacy. There's California, then you have, Mississippi, New York. They put forth things every year. Florida tried to get theirs passed. Washington tried to get theirs passed. Utah and Colorado did. Segue, Colorado's AG and California's AG are working together and are going to have like a joint kind of database and help investigate each other's. So keep that in Virginia didn't, they passed theirs. So, I run a lot of companies. They're like, well, why can't we be like Europe and get one national law that everybody can, abide by, instead of these, mostly consistent, but somewhat nuanced, state laws. And so in response to that, and I'll be honest, the companies would rather have a federal law because they have more influence at the federal level as far as lobbying goes. So the reason why California got here real quick is because it was kind of a ballot initiative.
Nope.
My camera down. Snuck in at the last minute, and the lobbying groups couldn't get around it. So, and I know this from talking to various lobbyists. So they tried to change it, but they killed the Washington bill, they killed the Virginia bill. They want to get rid of the private cause of action, amongst other things. So that's the big problem.
Okay.
And so they went to DC and a lot of the companies you can think of, and they said, we want to come up with a federal law. And they've been saying this for years. And my whole thing was, Nancy Pelosi was on record 4 years ago, saying she would never bring anything to the floor of the House that had less protections than the CCPA, which kind of killed everything there and then. She's now no longer in charge and on her way out. So last year, in the middle of the summer, Congress got together, or the House, with the American Data Privacy and Protection Act, the ADPPA. So, and it does, in a way, some decent things. I was surprised, but it pushes out the cause of action to, we'll talk about it in 4 years. We'll talk all the hard stuff. They changed that to 2, but you could see where this was going. Then the FTC was going to enforce it. And set up their own privacy bureau. If you weren't following the last administration, the FTC enforcement got cut to, somebody can correct me if I'm wrong, from like 47 people to 22 people investigating this stuff on behalf of the whole country. And now they wanted them to investigate, and this would supersede all the state laws. So the California folks, the representatives, say, no, we want to carve out CCPA. So now it's stuck. Bottom line is, this passed the House. It's in Senate for committee. Will it come up for a vote this year in the Senate and then be signed by the president? Probably not, because we also have the abortion decision that get thrown into there. And this Privacy Act would let them spy on you for anything related to crimes, and it gets real messy. So when they wrote this, I don't think that's what they were going for. But now the left doesn't want it, and now the right wants it, but only if California, because what good to a company is it if California is still there, their CPRA, and then you give us this new federal law. But it's gotten farther. I was surprised it's gotten as far as it has. It does do some good things, but I think by the time they carve out everything that needs to be carved out to get it passed, it's going to be kind of dead in the water. And make no mistake, this is authored by, I'm not going to name, I know 4 people that actually wrote on this that are company representatives in DC. So. And they kicked everything that's hard down the, yeah, sure, in 4 years, we'll the cause of action for, us not reasonably protecting your data or not doing what we say we're doing, we'll worry about it in 4 years. And then I lived in DC a while. Anytime you start adding that kind of timelines, nothing ever gets enforced. So, and that's
so
go ahead.
So no, I don't want to cut you off. So, but I want to ask you one more question on this before we go back to the TikTok conversation. So, in your opinion, do you think that this meets the level of adequacy in the eyes of, say, the EU, if they were to do this? No. Okay.
That's a whole other. So there's also, sum this up in a minute, an ongoing. So the U.S. is not deemed adequate by the EU. Set the UK aside, meaning data can't come from EU residents into the US without, standard contractual clauses, BCRs, a couple different ways. If you remember Privacy Shield, that one got invalidated. Privacy 2, that got invalidated. So now there's a new push for the EU to grant an adequacy decision. Biden gave an executive order last year saying, oh no, our CIA and all of our deep packet inspection of all your data, it's only going to happen if we think there's a crime, but that's not really true. So this new federal, if this ADPPA passed, I don't think the EU would, it's not a magic bullet because we still do surveillance like that, right? It's not going to solve that. The UK now, which is starting their own GDPR light, they might be like, cool, they want to open up more business ties, but they're angering the EU. So you're going to have the UK and EU, they're fighting right now. So this doesn't get to that adequacy level, but that adequacy level to receive EU data, it's being worked on. Basically, Privacy Shield 3 is coming around the corner with the exact same language. Well, mostly the same language.
Mostly.
And then Matt Krems and his team will sue on that, and then we'll see where we go. But you're seeing splits. In general, Germany is going to require the SECs no matter what. Spain's shown a little bit of leeway to maybe bend a little bit, right? Belgium, France, so it's starting, and this is GDPR. Sorry, we're off of, but we got a federal ADPPA that had some, it would be referenced, but you're starting to see the pro-business side win. I mean, you just had the Ireland DP completely at war with the European Data Protection Board over the Facebook Meta fines. So they're basically, and for those who know, Ireland's kind of like a Facebook state. They've spent years by buying real estate, buildings. They're their largest foreign, and they owe it. And the DPC there has been considered kind of like a not very strong when it comes to, but so you're seeing a split there. Certain countries pushing back, and it always is interesting for somebody in my perspective to try to guide a company. So what do we do, right? You tend to pick which regulations apply to you. What jurisdictions do you fall into? Try to take the conservative approach if you can, and understand where your data is. Why? This is the biggest question. Why do you have what you have? That question can lead to weeks of conversation. If you don't need a field of data, don't collect a field of data, or kill it when you have it. Don't just, storage is cheap. Okay. I mean, I have a client that said that for 14 years until he realized he had 7.5 terabytes of departed employee email, which the California regs would, as of this year, we don't know, maybe somebody you fired wants to make a data subject action request. And now they had no way of finding, it was going to take forever to figure that out. So we used that CPRA last November to make a move to get rid of departed employee data, because we finally got the attention of higher ups and the board, and to say, this could be a problem. It's cheaper to do this. Don't just keep data and know why you have it. Those are general principles about anything.
Well, so I know we're limited on time. So first I want to let everybody know, please feel free to ask any additional questions or email us at any time, and we'll be glad to follow up. As you can see, privacy is a broad subject. We've hit just on 2 small subjects here, and we're going to end with one last one. We are always glad to have these conversations with anybody. Tom's group specifically focuses on this, and as you can see, he is a wealth of knowledge that has helped me many times as well. So I'm going to kind of dig into this very last one. So we had, of our responses, 77% of the people here that responded said yes, employers, should ban social media platforms like TikTok from their network. Tom, why was this, something that was on your mind when you and I were chatting earlier?
I'll take that as a win, but the other 23%, would it change your mind if you knew they tracked your keystrokes across other apps, possibly?
I'd be curious.
But, sometimes people are like, what? So one thing with these social media apps, a lot of them are taking information from other social media apps, not just within the meta world or within. So when you're clicking all those things on your iPhone to green, saying, oh yeah, you can have access to my camera, my phone, my pictures, my contacts, think about it. I do live in a paranoid world. I will admit that. I use fake information for my Walgreens card, for everything. Like I know I'm not really winning that game, but I still can't justifiably give over any of my information. But yeah, it's interesting to follow. In China, like, for example, the state cuts access to TikTok for people under the age, I think, of 18 at 11 p.m.
Yeah.
Country that made it doesn't let their own kids. I have a 15-year-old, so I understand the world we live in. you think we can learn from that. They even know it's addictive and terrifying for parents and things like that. But yeah, I'm not. You don't say I'm not a fan, but it's not just that app. But I think those are discussions employers are going to have with employees. If they're going to have an employer-issued device, you should be able to determine what's on it. I don't think that violates privacy. I'm not looking what you're doing. I'm just saying you can't do X, Y, and Z. If you want to make freedom of speech arguments, get your own phone. Do what you want. And that's what I think would be the wiser approach. Sorry, we're right at 3:00.
No, we're perfect. Well, Tom, I know you and I can sit here and talk about it all day, and we didn't hit on a lot of points that we wanted to as well. So first, let me say thank you so much for joining us today and helping share a lot of this information that we know is going to be key and people need to start considering here. To everybody that joined us, thank you so much for joining us for our first session of the year. As a quick plug, in about 4 weeks from now, I'll be talking with some experts from Slack Data about similar type topics and how do we deal with privacy within Slack, and specifically how do we also modernize and help with collections, and what can we do there? How does Slack impact your discovery and your litigation process? But Tom, thank you so much for the information today. I know you and I will talk, and anybody, please, like I said, please feel free to reach out to us. This is a conversation that we should be having more on a regular basis, and it probably is going to impact you or your company here in the very near future if it hasn't already. Again, from R. Mandel from Gulfstream Legal and Tom Madsen from Madsen Consulting, thank you so much for joining us today.
Thank you, everybody.
Thank you, Tom. Bye-bye.